Yes, good evening to everybody. Welcome to the class of the family law, and we are dealing the gift that is hiba in Muslim law. And some of the part we dealt it yesterday, the remaining part that we would like to do today. Yes, what I posted on the screen, can anybody will read? Unmute and read.
Good evening to the legal fraternity. Hiba, a gift, hiba. In Muslim law, gift, bargiul, hiba. In Muslim law.
Appreciate.
Professor Dr. Mohammed Saheb Hussain.
Yes. Now let us see what is hiba. And let us come to the word yes. And we know the interviewers means both are living together. Means both are alive. That is interviewers. And that is, there are two types of the disposition would be there for the property giving. One is interstate, another is, what is interstate? Interviewers, another is testamentary disposition. Testamentary disposition means?
Will, by
Yes.
way of will. Will,
By
sir.
writing a will, by executing a will. So yesterday that I made it very much clear to you that Muhammad law permits both the kinds of dispositions, but while a disposition intervals means both the parties should be present, is unfettered, I told you. Unfettered means unlimited. As to the quantum, testamentary disposition is limited. In the testamentary disposition, it is only one third should be given the property. Who? Propositors, who is going to die, or the donor.
Proposal.
But here we will say donor. Okay. Muhammad Allah allows. You know, I told you what is fettered. I told you yesterday.
Bandinchadam, sir.
Hmm?
Bandinchadam.
Yes, this is the fettered actually. See, keeping aloof only little space. ఇక్కడ చూసారా ఎంత స్పేస్ ఉంది? Yes. Did you observe this photograph?
Yes, sir.
Yes, sir.
Only little space is there. In the same manner, fettered means the space is little. Unfettered means to the extent, maximum. That is the word they used over here. So that is fettered actually. So in the testamentary, it is one third should be given over there. Muhammad Allah allows a man to give away the whole of his property during his lifetime, but it's only theoretical, I told you. But only one third of it can be bequeathed by the will. From that of a will, a gift may be made to the stranger, wholly excluding the heirs. No, you cannot give the gift to the stranger by excluding the heir. It is only theoretical. Practical. Practical. Say
Impossible.
nil.
Well.
Practical nil. Not implemented. No. Pardhanashil lady. Who is the Pardhanashil lady? Yes.
Burqa.
In one way.
Muslim lady.
Actually, a woman who is secluded, meeting with the other people except the father and mother and the own relatives, and observing the every fundamental things of Islam, and such a woman is said to be the Pardhanashil lady. So Pardhanashil lady, free consent means the consent should not have been obtained by the fraud, misrepresentation, or undue influence. These are the things I told you. But yesterday also I told you that a man put the revolver near to the kanta. I told you kanta. What is that kanta in English? I told you yesterday. Sir, yesterday no sir, we have forgotten, sir. Yes. If you don't know, say pass on. Sir, we are feeling shy, sir.
Pass on, sir. Pass on.
Donor, sir.
Kanta. I'll show you. See, I'm making on. This is the kanta. Did you see it now? Temple. Temple. Could you see my photo? Say yes or no?
No, sir.
This is kanta. Okay. So that is called temple. Okay. Now, so by force, if anybody has taken the consent, it will not amount to the gift. That is the thing here. I put the asterisk here so that I could know that I have covered up to that extent. Now the donee. Who is the donee?
To whom the property is transferred.
Who
Gift is
accepted?
transferred. Gift is transferred. Who receives the gift, sir?
Who receives the gift is called the donee. Who accepts the gift is called the donee. The donee is the person who accepts the gift by or on behalf of a person who is not a competent to contract. In case the donee is not competent to contract, on behalf mother, any legal guardian could take care of it. A minor, therefore, may be a donee. A minor, therefore, may be a donee. But if the gift is onerous, the obligation cannot be enforced against him while he is a minor. See, the onerous, will see the type of the gifts will come, the onerous gift and other types of the gift would be there. But in any case, a minor cannot be a donor. Am I right?
Yes, sir.
Yes. Yes, sir.
What is the reason?
According to Indian Majority Act.
Yes,
18.
he could not. He is below the age of the 18 years. He is a minority, hence we cannot be make a contract. Okay, the obligation can't be enforced against him while he is a minor. But when he attains the majority, he must either accept the burden or return the gift. Suppose if he attains the majority, there is a two choices left to him. Either he accepts the gift or he renounces the gift, means return back the gift. Okay. Suppose the donor is died, then when he attains the majority, by the time the
Gift is
donor is
void, sir.
died,
Gift
yes,
is void. Gift is
legal
void.
heirs will take it. Am I right? Say yes.
Yes, sir.
Okay. The words accepted by or on behalf of the donee show that the donee may be a person unable to express the acceptance. A gift can be made to a child inventor samere and would be accepted on its behalf. When the child is in the womb, at that instance also it can be accepted over there because mother accepted it. Mother accepted it on behalf of the child who is there in the womb. Yes, the donee must be an acceptable person and he is donee under this section, nor can a gift be made to an unregistered society. So, a gift cannot be made to an unregistered society. Means a gift could be registered only the registered society or a legal person or juristic person. A gift to two or more persons may be gift to them as a joint tenants or the tenants in common. Either it can be given the two person, more than two persons also, either jointly or in common way. The presumption of English law in favor of the joint tenancy does not apply in the Hindu gift. Of course, a little difference would be there in the Hindu law and the English law. In Hindu gift, the donee are presumed to take the tenants in common. Yes, Hindu law will allow it, but it is not allowed in the English law. It is necessary Mohammedan law that donee should accept the hiba and the possession must be delivered in the case of hiba. So either the hiba or the gift. The thing is, whatever the thing that you want to give it, it should be the position should be given to the donee. Suppose it is a movable property, it should be handed over to the donee. Suppose it is a immovable property, then it should be registered on the name of the donee without any condition. A hiba is the immediate and the absolute transfer of ownership. A hiba in favor of a person who was not in existence is invalid. A person who is not in existence is invalid. But what about the interest of a mere, that is a fetus in the womb? Yes, it is deemed that it is alive. Is it clear?
Clear, sir.
Yes, as hiba is the immediate and absolute transfer of the ownership, a hiba in favor of a person who was not in existence is invalid. It is necessary that the donee should be accept the hiba and a position must be delivered in the case of the hiba. So a possession should be delivered over there, or merely saying it does not amount to the gift. Unconditionally, absolutely should be transferred, or a disposition should be made to the donee. Yes, as a hiba, immediate and absolute transfer of the ownership, a hiba in favor of a person who was not in existence is invalid. A person who is going to take the hiba, that means donee, is no more in existence, then it is invalid. Is it clear?
Yes, sir.
Yes, sir.
Yes. Now read this one. Only one. If you read anyone one, next time I say then next person should have read it. Yes. Start with anyone.
Gifts of usufruct ariat to unborn persons. A hiba stands on a different footing from a gift of a limited interest in a usufruct. A gift of future usufruct to unborn persons is valid provided that the donee is in being at the time when interest open out for heirs.
Yes. There is another type of the hiba is there. There is a ariyat. Ariyat means only enjoying the fruits of it. Usufruct, harvest. Like I told you, the mango grew. Yes, he can give the gift to the mango grew. Okay, you can cut all mangoes. Yes. What is the harvest should be there on the particular season, it will be taken in the form of a gift, it can be given over there. A type of the gift here. Here, neither the trees are transferred on his name, nor any other thing. Land is transferred on him. Only the usufruct means benefits, harvest could be enjoyed by the donee. It is the one of it is another type of the gift. Okay, a child in the womb. A hiba in favor of the child in the womb is a valid if the child is born within 6 months from the date of the hiba, because it is presumed that the child actually existed as a distinct entity in the womb of his mother. Yes, a child in the womb also be taken as a juristic personality, but the only that he should be viable, and within 6 months the child should be born. That is the valid gift. Okay. Next, just juristic person. Who is juristic person? A gift to a juristic person or any other institution is valid, like schools, churches, temples, and masjid. So a gift to a corporate units that Tawziya consisting of a mother and all her children, not descended in the female line, governed by the this Murkumattayam law, are valid. Such a gift will be valid as being one for the whole body. It is the one clan also it can be given the gift. And it has been held that the mosque is recognized by the Muhammad Allah jurist is a juristic person, and that a valid gift can be made in favor of a mosque, temple, and church, gurudwara also, because they are all called
Juristic persons.
juristic personality. Appreciate. Gift to non-Muslim. A gift may be made to a non-Muslim, okay, but in such a case, the property will, after the completion of a gift, be subject to the personal law of the donee and not of the donor. At the time, the donee personal law can be used there, but not the of donor can be used when the gift is given to the non-Muslim. Then Muslim law should not be followed over there. Suppose the donee is a Hindu law should be followed. If the donee is a Christian law would be followed. Okay, that is the thing. Subject to a gift. What are the subject can be given as a gift? Yes. What are the subject will be given as a gift? Taj Mahal? Yes.
No, sir.
A person who is giving the gift should be the owner of the gift. So the object matter of the gift must be certain existing, movable or immovable. It may be land or goods or actionable claims. What is actionable claims? Anyone? Actionable claims means, if you know it, you tell me. If you don't know
Yes, sir.
it,
Money.
yes,
Money.
yes,
Money, sir.
person,
Person,
actionable
sir.
claim. Actionable claim means a right will be given. Suppose somebody is due to you, and you will give that right to you. Okay, you can claim from him. That is called actionable claim. And yes, it is an actionable claim. Also can be given in the form of the gift, and it must be transferable under Section 6 of the that is the Transfer of Property Act. But it cannot be a future property. The property which is going to get after the death of the father, you cannot make the gift of that property. But you can make a will. Okay, because will come only after the death of the father. Yeah, a gift of your right of management is valid. Yes, it is a gift of right of management is valid. If the right you are giving, yes, that is a valid gift. But a gift of the future revenue of a village is invalid. So whatever you are going to get in the future revenue for the village, that is invalid, because that should be definitely, and that should be existence. These are the important factors, the subject matter of the gift. These cases were decided under the Hindu and Muhammadan law respectively, but they illustrate the principle. In a Calcutta case, it was said that the release of the debt is not a gift. Yes, a release of a debt is not a gift. What is it? It is waiving of the debt. Are you following me? Suppose
Yes, sir.
somebody is due and you said, okay, you need not to pay. Means you are relieving him, but it is not a gift. You are waiving your right. Are you following me? See, either you are waiving a gift or a gift doesn't make any difference to the person who is due to you. Is it or not?
Yes, sir.
Yes,
Yes,
yes.
sir.
Yes, Muhammadan law respectively, but they illustrated that in a Calcutta case, the same thing. A debt is not a gift. As a gift must be a tangible property. Why tangible property? Even a gift can be actionable right also. And it is submitted that the release of the debt is not a gift, as it does not involve the transfer of property, but is merely a renunciation of the right of action. Here, the right of action will be waived out. That's why they will say it is not a transfer of property, and hence it will not catch the definition of the gift. It is quite clear that in an actionable claim, such as the policy of the insurance, may be the subject of a gift. It is submitted that in an idea of the gift, the meaning of the word money should not be restricted by any other hard and fast rule, but should be interpreted having the regard to the context of the property, construed in the light of all the relevant facts. Suppose your father is having the life insurance policy, and there is a nominee also there. So, nominee, your father dies over there, or the maturity would be there, and he is not alive, the nominee is entitled to get it. So, naturally, the amount which you are entitled to get it, the matured amount, it is said to be the gift. It is said to be the same. Say,
Gift.
Gift.
it is a gift only. See, any property which you got it without your consideration, without your sweat, that is a gift only. Are you following me?
Yes, sir.
సార్ రోడ్ మీద మీకు రోలెక్స్ వాచ్ దొరికింది, సో దేవుడు మీకు గిఫ్ట్ ఇచ్చినట్టే కదా అది. ఎస్.
Sir. Sir.
So because you did not work hard, you got it. So in one way, in another, it is a form of a gift to you. But if the original oral would be found over there, then you should have supposed to transfer that property to him. Is it clear?
Yes, sir.
So this is the even. Therefore, in order to constitute a valid gift, there must be an existing property. In Muhammadan law, any property or right which has some legal value may be the subject of a gift. Some legal value, some consideration. Yes, it is deemed a gift. Now let us see what is the condition for the valid gift under Section 122 of the Transfer of Property Act. There was a divergence of view between the two schools of Hindu law as to the necessity of the acceptance of gift by the Doni Dayabhaga school, holding that it was not necessary, but with Akshara holding that the contrary. The section has modified the indigenous Dayabhaga law, a transfer of stock to the name of the Doni vests in the property in him, subject to his right to repudiate the gift. See, there are the two schools in the Hindu law, Dayabhaga and Mitakshara. In which school that we belong? Generally, the south, here, Telangana are upper part of it. Yes? Sir, Mark Dilesh, sir.
Hindu law, sir.
There are two schools are there. Are you belong to the Mitakshara or you belong to the Dayabhaga? You tell me, Bindu. Sir, I don't know, sir. Tamilians, they take the Dayabhaga. All other upper part, they will take the Mitakshara school. Mitakshara school, there is a co-personal rights. But Dayabhaga school, there is no co-personal rights. Of course, This is a little knowledge I am having it, but there is a slight distinction between the two. A transfer of the stock to the name of the donee vests in the property in him, subject to his right to repudiate the gift. Suppose if you are given the gift to the donee, and a donee having every right to either to accept the gift or to repudiate the gift. Are you following me?
Yes, sir.
Even though the unaware of the transfer, and it is so even though the gift be onerous. Onerous gift means, of course, there is a onerous gift, you will read it after some time. The mutation entries of the property alleged to be the gifted does not convey to extinguish the title, and those entities are relevant only for the purpose of the collection of the land revenue. Here, what I want to say is, whatever the thing that you want to give to the in the form of the gift, that should be in existence. Either it may be the movable property or it may be the immovable property. Either it may be the tangible property or it may be the intangible property. But intangible only actionable rights. Gift defined under the Transfer of Property Act is given below. Section 122, gift defined. Gift is the transfer of certain existing movable or immovable property made voluntarily without consideration by one person called the donor to another called the donee and accepted by the or on behalf of the donee. So how many partners are there? How many characters are there? How many players are there? Yes.
Donor, donee, sir.
Yes.
Character.
What is the subject matter?
Movable, immovable property.
Or tangible or intangible also. Actionable claims are also a gift. Yes, but the donee should have to accept it, or on behalf of the donee, somebody may also accept it. Is it clear? Is there any consideration?
No consideration, sir.
But love and affection also a consideration. Okay, but here generally we will say the love and affection, but love and affection you try to don't show to the pedestrian. Please. So it is required to be the voluntary transfer of the property to another made gratuitously and without consideration. See, what is a gratuitous contract? Anyone? తెలుస్తే చెప్పండి.
Voluntarily, sir. Voluntarily.
Example. Suppose you are traveling in a bus and the bus conductor came to you to, they say, please pay the money and take the ticket. So when you put your hand, you found some 10 rupees is less. But he said, no, you get down. Otherwise, I don't accept you. So somebody is adjacent to a good Samaritan. He has given the 10 rupees to you, and he has given to the conductor. He purchased the ticket. The adjacent person who has given the 10 rupees is a contract or gratuitous?
Gratitude.
దయదలిసి ఇచ్చింది దాన్ని gratuitous అంటారు. But he cannot ask it when he is given the gratuitously. So a person, the section applies to those gifts that are given, gifts interviewers an absolute gift. So here gratuitous and without consideration. So whether is voluntarily given over there without expecting anything. Sir, you give the beggar some alms. Why do you give the beggar alms? It's a gratuitous act.
Gratitude.
Yes.
With gratitude.
He will bless you. Are you following me?
Sir.
Yeah, this section applies to those gifts that are gifts interviewers. Means the both parties should be alive or an absolute gift. Property under the above section can be both the movable or immovable property. However, have to be tangible in nature. Generally, the property would be taken into the tangible nature will be considered. In order to constitute a valid gift, there must be an existing property as already earlier elaborated. So the property should be in existence, not that you are going to get after you are attaining the 18 years. No. Or not you are going to get after your marriage, because anyway the father-in-law, mother-in-law promised to give the bullet to you and money to you. Okay, that will not be there. If you given or not given, there is a different issue. But when you are making the gift, it should be in existence. The property should be in existence. That is more important. So, the act also voluntary act. In this section, the word voluntarily bears It's the ordinary popular meaning in denoting the exercise of the unfettered free will. Unfettered free will, the voluntary act, and it's a technical meaning of the without consideration. Can you give me one example for the voluntary act? Yes. If anything done voluntarily is said to be the voluntary act. Is it or not? Is it or
Yes, sir.
not?
Yes, sir.
Then what about the breathing? What about the breathing? Sir, we don't know. See, if you don't breathe, you will die. So it is automatically you breathe it. It is an involuntary act in one way, in another way. What about snoring? అసలు మాకు స్నోరింగ్ అంటే చెప్పండి సార్, ఏంటిది అది అర్థం?
Voluntary act, sir.
ఎస్.
Voluntary act, sir.
No, what is meant by snoring? You tell me the meaning of snoring.
Uraka.
Yes,
Involuntary.
yes. Yes, now is the voluntary act or involuntary act? It is an involuntary act. చెంపదెబ్బని ఏమనాలని ఇంగ్లీష్లో తెలుస్తే చెప్పండి, లేకుంటే పాస్ అని అనండి సార్. రిపీట్.
Slap.
Slap, yes. So slap is a voluntary act or involuntary act?
Voluntary.
Sir, లేదు సార్ అది, because I saw there is a mosquito on her cheek or on his cheek, so I want to kill the mosquito, that's why he made a slap. You will get the 2 slaps if you saw, because he saw the 2 mosquitoes on your 2 cheeks. Okay, when a gift is made, it must be satisfactorily appear that the donor knew what he was doing and understand the content of the instrument and its effect. So whatever the act he is doing, he should know it what that he is doing, and also that the undue influence or pressure or not exercised upon clear intention to make out and out gift. So there should be a voluntary act, and there should not be coercion, there not be undue influence. So these are the things would be there when a person wants to give the gift to another person. But the intention has failed for the want of the transfer of any other cause. The courts will not convert what was meant to be an out and out gift into a trust, and the donor will not be deemed trustee of the property of the intended donee. Suppose merely having the intention to do it, but he did not put it in practice in the action, then it is not amount to the transferring the gift or disposing the gift. So the gift will fail. Also, where the husband deposited certain ornament with a bank for the safe custody in the joint names of himself and his wife, with the direction to be delivered to be either or survivor. If any one of the people will survive, for them the locker ornaments will be given to them, or him or her. It did not amount to a gift, as the husband remained dominion over the property. Is it a gift if you are keeping in the locker? Or the wife died, her husband died, so they are giving it. It is your property. Are you following me?
Yes, sir.
Following me?
Yes, sir.
Your property you are depositing in the safety locker, and in the name of the wife and husband. If any one of the spouse died, what will happen? If any one of the spouse died, the other spouse, those who are surviving, will going to get it. Do you think that is a gift? Answer is
Yes, sir. Gift.
అది మీ ప్రాపర్టీ అండి, మీరు ప్రాపర్టీ మీరు లాకర్లో పెట్టుకున్నారు, ఇద్దరి పేర్ల మీద, వైఫ్ అండ్ హస్బెండ్ మీద పేరు మీద పెట్టారు. ఇఫ్ ఎనీ వన్ ఆఫ్ దమ్ డైడ్ ఈస్ దేర్, ద సెకండ్ పర్సన్ ఈస్ గోయింగ్ టు గెట్ ఇట్. హౌ కుడ్ యూ సే ఇట్స్ ఎ గిఫ్ట్? ఈజ్ ఇట్ నాట్ యువర్ ప్రాపర్టీ?
Yes, our property.
It is your property. Am I right?
Yes, sir.
Why
Yes,
you are
sir.
taking? Why is it so confusion? Is
No,
it so
sir.
confusion? అరే లాకర్లో మీ ప్రాపర్టీ పెట్టిందండి ఇద్దరు పేరు మీద. వన్ ఆఫ్ దెమ్ డైడ్ న్యాచురల్లీ ద అదర్ కెన్ క్లైమ్ ఇట్. నో, ఇట్ ఈస్ నాట్ ఏ గిఫ్ట్. సో గిఫ్ట్ అనేది ఎప్పుడంటే ఇట్ ఈస్ నాట్ యువర్ ప్రాపర్టీ, గెటింగ్ ఇట్ వితౌట్ ఎనీ కన్సిడరేషన్, దట్ ఈస్ ఎ గిఫ్ట్. వేర్ ఎ పర్సన్ కీప్స్ మనీ టు ఫిక్స్డ్ డిపాజిట్, ఇఫ్ ఎ పర్సన్ ఈస్ కీప్ టు ద ఫిక్స్డ్ డిపాజిట్ ఉన్నది, husband retain the dominion over it, where a person keeps the to fixed deposit in the name of his niece, brought up and given in a marriage by him. There is an interference with the, there is the interference where the person keeps the money to fixed deposit in the name of his niece, brought up and given the marriage by him. There is an interference of a gift in favor of the niece. Now you tell me, there is it a gift where a person keeps money to fixed deposit in the name of his niece, brought up and given in the marriage by him? There is the interference of gift in favor of the niece. See, when something is given without consideration, yes, that is the amount of gift. Is it or not?
Yes, sir.
Is it the money of the niece? Is it the money of the niece?
No,
No.
sir.
It is kept on the name of the niece. It is kept on the name of the niece. It is not the money of the niece. At that instance, fixed deposit will be there. Later, if he wants, he can give it to the niece in the marriage. If not, he can keep it with him also. But with the intention is there, he wants to give to the marriage, because with that intention, he made the fixed deposit. So whatever the amount will come after the 15 years or 20 years, then that amount would be given. Then we can say it is a gift. Okay? There is no interference of a gift in favor of the niece. There is no interference means, yes, it can be a gift. Where the motive behind the deal, deed, not deal. Deed ante ఏంటిదండి?
Copy, sir. Document.
Document. Don't say copy, say document. Behind the deed, a gift was unequivocal, means not be compromised, to give the transfer a title which would act as a safeguard against any claim for the preemption. The transaction for that reason can't be called a sale. So there is a sale or not a sale. Preemption అనేది ఏంటి? Preemption అంటే తెలుసా అండి మీకు? Yes?
అనుకోవడం.
Ah.
Presumption.
Preemption, not presumption. Preemption, PREMPTION, preemption. Suppose a land would be there, adjacent land, they are going to sell it, but you have to sell to that person who is adjacent to it, but not to the stranger or a far away person. That is called preemption. ఏమో సార్ మీరు చెప్పిన మీరు అయిపోయింది. ఇక్కడ కొడతా కదా, ఇప్పుడు చెప్పేది కదా, మీరు చదవాలి కదా. ఇప్పుడు ప్రియంషన్ అంటారు దాన్ని. మీరు చదవండి ఇప్పుడు. ప్రియంషన్, చదవండి ఇక.
The purchase of goods or shares by one person or party before the opportunity is offered to others. The action of preempting or forestalling, especially of making a preemptive attack.
సో ఏమన్నా అర్థమైందా అండి ప్రియంషన్ అంటే ఇప్పుడు? డిడ్ యూ గెట్ ఎనీథింగ్? సే ఎస్ ఆర్ నో. Say yes or no. Say yes or no.
Sir, yes, sir.
ఏంటి చెప్పండి, ఎక్స్ప్లెయిన్. Explain. No, sir. If any property would be there, where the owner of your property, an adjacent person is going to sell the property, which is very adjacent to your property, and first and foremost, he should ask you, sir, whether you are going to purchase this property or not, because it is very much adjacent to you. And if you say no, then he can sell to the other person. Such a right is called preemption. Is it clear?
Yes, sir.
సిగ్గుపడకండి, డోంట్ ఫీల్ ఇట్. తెలియకపోతే తెలియదని చెప్పండి. సార్ ఎన్నిసార్లు చెప్పాను సార్, ఒక్క 50 నిమిషాల్లో పాసాను 52 సార్లు చెప్పినా సార్ నేను. ఏమైతుంది, ఇవాళ చెప్పింది 52 టైమ్స్, నెక్స్ట్ టైం 50 చెప్తారు, నెక్స్ట్ టైం 48 అవుతుంది, నెక్స్ట్ టైం 40 అవుతుంది, నెక్స్ట్ టైం 30 అవుతుంది, నెక్స్ట్ టైం 20 అవుతుంది, నెక్స్ట్ టైం 0 అవుతుంది. Okay, where the motive behind the deed of the gift was unequivocal. This we already read it. Donative intention or motive and consideration. Yeah, the motive should be there, intention should be there, then only, and there should not be any consideration, and then only it is amount to the gift. A gift is a transfer, yes, definitely a transfer, but it does not contain any element of the consideration. Yes, there is no element of the consideration in return. A complete absence of the monetary consideration. Yes, there is no money played over there, only love and affection it will be played over there. And hallmark, which is a distinguishes a gift from a grant, or any other transaction for the valuable and adequate consideration. There are two parties should be there. The two parties should be alive, and the subject matter would be there. And subject matter ownership is the donor, and he is having the clear intention to give in the form of a gift to the donee, and he has to execute it, and absolute power that he has to give it. Then only you can say it is a gift. Where there is any equivalent of the benefit measured the terms of the money in respect of the gift, the transaction ceases to be a gift. Suppose if you are given the house for the gift, okay, well and good. Give the key, yes, give the key. Registered, yes, registered. But some rooms where you are giving for the rent, the rent should have been given to the donor. Is it a gift?
Yes, sir.
No. Whenever given the house, entire house to the donee, again you should not get any benefit from the house. How could you take the rent? Is it not conditional? Is it not conditional?
Yes, sir.
What the gift says? Absolute transfer, no conditional transfer. Is it clear?
Yes, sir.
Yes, sir.
Good. Love and affection, spiritual benefit, and many other factors may be either the intention of the donor to make a gift, but these financial consideration cannot be called and held to be the legal consideration. See, we can give our love and affection because our kith and kin and blood relations and many other factors plays an important role, and hence we will give the gift to somebody else. Legal consideration is on the recognized or permitted by the law as a valid and lawful. The term also sometimes used as the equivalent to the good or sufficient consideration. Love and affection is the sufficient consideration when the gift is contemplated. That is the reason that we are not supposed to give the gift to the Darinaboye Danaya. That is means pedestrian. But it is not considered as a valuable consideration when such a required. Sir, Dari when a Danago Nilu Dagipicha. Yes, if it is summer, you can provide the water to him because he is thirsty. Providing the water is the water to the pedestrian. Is it a gift? Yes.
No, sir.
No, sir. Sir.
It is only alms. Adi alms aitadi. Danam aitadi. Gift kadadi. Sadaka aitadi. Is it clear?
Yes, sir.
Okay. It is one of the essential requirement of the gift that it should be made by the donor without consideration. Means there should not be any consideration. The word consideration has not been defined in the TP Act, but means the same as in the Contract Act, excluding the natural love and affection. Which section says about the consideration in the Indian Contract Act? First semester, sorry, yes. If I not be mistaken, it is section 25.
Section 2D, sir.
Huh?
Section 2D, sir.
25. If not, and if the transfer involved the consideration, the transaction would amount to a sale within the meaning of the section 54. Where the money played an important role over there, we don't say it's a gift, we say it is a sale. Or exchange, if it is barter is there, one will give, another he will give it. Exchange is the meaning of the section 118. The sense of the gift inter vivos means both the parties should be alive, must be without consideration of the nature defined in the section 2, class D of the Contract Act. సార్ ఇక్కడ మీరు సబ్సెక్షన్ డి ఎందుకు అనలేదు సార్? ఇక్కడ సార్ మీరు సెక్షన్ 2 క్లాస్ డి అన్నారు. ఇక్కడ ఎందుకు అన్నారు సార్? మీరు సబ్సెక్షన్ డి ఎందుకు అనలేదు సార్? ఇక్కడ ఎవరన్నా అడగండి, మీరు అడుగుతారా? మీకు ఇప్పుడే చూపెడుతున్నాడండి. బికాస్ దిస్ ఇస్ టెక్నిక్, వన్ షుడ్ హావ్ టు నో ఇట్. ఈ టెక్నిక్ తెలుసుకోవాలి. ఇది ఎందుకన్నా నేను సెక్షన్ అనేది లా ఆఫ్ కాంట్రాక్ట్. See, all the definitions I repeat, all the definitions ఎట్లుంటాయంటే బేరాక్ట్ చూస్తే మంచిగా కనబడుతుంది. బేరాక్ట్ తీయాలి. Why you say that means definitions will come especially law of contract. Definitions comes specially in section 2, but in some places it will come under the 3. For instance, you take General Class Act is there, 1896, if I not be mistaken, it comes under 3. So here, interpretation clause is nothing but definition clause. Definition clause. Interpretation clause nothing but definition clause. ఈ డెఫినేషన్ క్లాస్ ఎట్లా చదువుతారనేది నేను చెప్తే ఇప్పుడు. నౌ ఐ విల్ టెల్ యూ ద సీక్రెట్. See, this is the interpretation clause. Is said to be the definition clause. ఓకే, ఇక్కడ తోక ఉన్నది చూడండి. తోక అంటే తెలుసా? ఇది దీన్ని తోక అంటారు. ఏమంటారు? ఇట్స్ ఎ టేల్ ఈస్ దేర్, ఇన్ ద ఎక్స్ప్లెనేషన్ ఈస్ దేర్, అండ్ బిఫోర్ ద ఈ టూని ఏమనాలండి? వాట్ ఈస్ దట్ టూ? ఏ న్యూమరల్ అనాలా? చెప్పండి, లేకపోతే పాస్ అనండి. డోంట్ వేస్ట్ ద టైం.
పాస్ ఆన్ సార్.
అరబిక్ న్యూమరల్ అంటారు దాన్ని. అది రోమన్ కాదు, అది రోమన్ క్యాపిటల్ కాదు, రోమన్ స్మాల్ కాదు, అది అరబిక్ న్యూమరల్ 1 2 3 4 5 అరబిక్ న్యూమరల్స్ అంటారు దాన్ని. సో దర్ ఇస్ ఎ 2 ఈజ్ అరబిక్ న్యూమరల్, దెన్ ఇట్ ఈస్ ఎ హెడింగ్ ఈజ్ దేర్, మీన్స్ సెక్షన్ హెడింగ్ అంటారు దాన్ని. ఏది ఇంటర్ప్రిటేషన్ క్లాస్ సెక్షన్ హెడింగ్ అంటారు. అది ఇక్కడ మాత్రం ఇంటర్ప్రిటేషన్ క్లాస్ దే పుట్ ఇట్ దేర్, అదర్వైజ్ దే సే డెఫినేషన్. అండ్ ఆఫ్టర్ ద డెఫినేషన్ ఇఫ్ ఎనీ ఎక్స్ప్లెనేషన్ ఫాలోస్ ఓవర్ దేర్, ఎక్స్ప్లెనేషన్ ఫాలో అయిందా లేదా? ఇక్కడ ఏంది ఎక్స్ప్లెనేషన్? ఇది in this act the following words or expression are used in the following senses unless a contrary intention appear from the context. ఇదేంటి సార్? ఇదేంటిది సింబల్ 2 చుక్కలు వర్టికల్లో ఉన్నాయి చూడండి. ఏమన్నారు దాన్ని? 2 చుక్కలు వర్టికల్లో ఉన్నాయి, ఏమన్నారా? పాస్ అన్నారండి సార్.
పాస్ ఆన్ సార్.
కోలన్ అంటారు. ఏమంటారు? కోలన్. చెప్పండి.
కోలన్.
ఆ తర్వాత డాష్. ఇట్లాంటిది వచ్చిందనుకో, ఈ టేల్ వచ్చిందనుకోండి సెక్షన్ తర్వాత, మిగతా జనరల్లీ అరబిక్ న్యూమరల్ రావు. వస్తే స్మాల్ లెటర్ ఏబిసిడి వస్తాయి, వస్తే స్మాల్ రోమన్ నెంబర్స్ ఉంటాయి, కానీ అరబిక్ న్యూమరల్ మాత్రం రావు. ఎప్పుడు? ఇట్లా టేల్ ఉన్నప్పుడు. అయితే ఈ టేల్ ఉన్న తర్వాత అరబిక్ న్యూమరల్ రాకుండా స్మాల్ ఏ ఇచ్చింది అనుకోండి, అప్పుడు సెక్షన్ 2 క్లాస్ ఏ అంటాం. ఇక్కడ ఏమంటాం?
సెక్షన్ 2 క్లాస్ ఏ.
ఇది డిస్టింక్షన్. ఇప్పుడు దాన్ని ఇంకోటి విధంగా చూపెడుతున్నానండి. ఇక్కడ ఏమనాలా అనేది ఇక్కడ అచ్చా, ఇప్పుడు చెప్పండి. ఇక్కడ ఏమనాలా సార్? ఇక్కడ సెక్షన్ 6 కాదు సార్ ఉన్నది. ఓకే సార్, ఇక్కడ కొంచెం తోక ఉన్నది కాదు సార్, మళ్ళీ కొంచెం తోక ఉన్నది కాదు సార్, ఉన్నది, కానీ స్మాల్ ఏ ఉన్నదా ఇక్కడ? స్మాల్ రోమన్ 1 ఉన్నదా ఇక్కడ?
లేదు సార్.
ఏది ఉన్నది? అరబిక్ న్యూమరల్ ఉన్నది. కాబట్టి దీన్ని ఏం చదువుతాం? చెప్పాలా? చెప్పలేకుంటే పాస్ అనండి మేడం గారు, నేను చెప్పేస్తా కదా ఇమీడియట్.
6 సబ్సెక్షన్ 1 సార్.
సెక్షన్ 6 సబ్సెక్షన్ 1 అంటారు దాన్ని, కానీ సెక్షన్ 6 క్లాస్ 1 అని మాత్రం అన్నారు. ఇస్ ఇట్ క్లియర్? సో see here there is no only section 8 is there, section 10 is there, nothing is there. Here 11 is also nothing is there, and 14, yes, here also 14 subsection 1, subsection 2, subsection 3, subsection 4, subsection 5 అంటాము. కానీ వేర్ దర్ ఇస్ స్మాల్ ఏ ఆర్ స్మాల్ రోమన్ 1, ఇక్కడ చూడండి. ఓకే, నౌ యూ టెల్ మీ. ఇందులో 16th ఉన్నది, అండూ ఇన్ఫ్లుయెన్స్ డిఫైన్ ఉన్నది. ఓకే, అండూ ఇన్ఫ్లుయెన్స్ డిఫైన్లో ఏమున్నది 2 ఉన్నది. అంటే ఏం చెప్పాలి ఇప్పుడు? సెక్షన్ 16 చెప్పండి.
Subsection 2, sir.
A.
సెక్షన్ 16 సబ్సెక్షన్ 2 ఇది చెప్పండి.
2. Class A. Section
సెక్షన్
16,
16
subsection 2,
సబ్సెక్షన్
Class
2
A.
క్లాస్ ఏ అని చెప్పాలా?
Class A.
దట్ ఈస్ ద వే ఆఫ్ చెప్పడం అనేది. ప్రొఫెసర్ హుస్సేన్ స్టూడెంట్స్ ఓన్లీ కెన్ డీల్ లైక్ దిస్. దిస్ ఈస్ మై ఓపెన్ ఛాలెంజ్ ఐ విల్ గివ్ యూ. Okay, where a very old man with a weak eyesight, sues for the cancellation of the deed of a gift executed by him in favor of his son, alleging that it was not his voluntary act. See, whenever the gift is executed over there, it should be voluntary act. The circumstances also indicated that the donee was in a position to dominate the will of the donor. See, here that fellow says, anyway, no rasichinna kadra vadi old man, now you cannot do anything. No. Till the donor is alive, he can change the will. Are you following me?
Yes, sir.
ఆర్ విల్ అని కానీ గిఫ్ట్ కూడా చేంజ్ చేయగలుగుతాడు. అంటే ఎట్లా ఇస్తానన్నా కానీ ఇయ్యలే కదా, అంటే ఒకసారి ట్రాన్స్ఫర్ చేసింది అనుకోండి, దెన్ ద ప్రాబ్లం కమ్స్ ఓవర్ దేర్. So the circumstances also indicated that donee was in a position to dominate the will of the donor. Under such circumstances, owner shift to the donee to prove that the gift was made voluntarily. So burden of proof ఎవరి మీద ఆధారపడి ఉంటుందండి ఇక్కడ? మా నాయన వాలంటరీగా నాకు ఇచ్చిండు. మై ఫాదర్ హ్యాస్ ఎగ్జిక్యూటెడ్ ఏ నాట్ గివెన్ ద గిఫ్ట్ వాలంటర్లీ. హూ హ్యాస్ టు ప్రూవ్? Donee has to prove, or on behalf of the donee, somebody should have to take care of. If the donee is a minor. In other case, Orissa High Court, gift deed is alleged to have been taken from the Pardanashin lady by practicing fraud. పాపం పరదానషిన్ లేడీకి ఏం చేసిండు? ఫ్రాడ్ చేసి ఆమె దగ్గరికి వెళ్ళి గిఫ్ట్ తీసుకున్నారు. ఏమని? బికాజ్ షీ రెడ్ సంథింగ్ విచ్ ఈస్ నాట్ రిటర్న్ ఇన్ ద పేపర్, అండ్ షీ థాట్ దట్ ద సేమ్ థింగ్ ఈస్ రిటర్న్ ఇన్ ద పేపర్. విత్ దట్ వ్యూ షీ సైన్డ్ ఇట్. So when the plaintiff is illiterate or a Padhanashin lady, in spite of the fact that she is unable to establish her case of the practicing fraud, the owner still remains upon the donee to establish conclusively that the document was executed after it was read over and explained to her, and after she understood the contents of thereof, then only she signed it. Who has to prove this thing? Donee has to prove. Of the Padhanashin lady, who is illiterate, doesn't know the language, but they read the language, which is not written over there, but she signed it, and it doesn't mean that she signed with the consent. Is it clear?
Yes, sir.
Yes, without consideration. A gift is a transfer without consideration, and if there is any consideration in any shape, there is no gift. Any consideration in any shape, there is not amount of gift. The word consideration means valuable consideration. There is a consideration either the form of money or money's worth, a gift in lieu of the conferring a spiritual